Be ready. 5 seconds.
Our Prime Minister injected new life and spirit and vigor into the fishery sector and aquaculture sector, which was long forgotten and was not visible during the previous governments. Probably it was unimaginable to apply this department for the economic growth of our country. The budgetary allocation in the previous governments for this department shows how neglected this department was. Under the able leadership of a great champion like our Prime Minister, a revolutionary scheme has been introduced to enable our fish farmers, fishers, and all the stakeholders working in the field to stand on their own feet and contribute for the economic growth of our country. This amendment became a necessity and became inevitable. We know that coastal aquaculture is mostly in the form of brackish water. Shrimp culture witnessed rapid growth in 80s and 90s. This growth was mostly unregulated, which drew widespread concern, and the matter went to the Supreme Court. The Supreme Court, in its judgment, held that shrimp aquaculture is an industry and hence covered by the prohibition imposed in the Coastal Regulation Zone notification. Accordingly, it ordered, among other things, that no shrimp culture pond can be set up within the Coastal Regulation Zone and that all shrimp culture industries or ponds operating in Coastal Regulation Zone are to be demolished and that the central government shall constitute an authority under Environment Protection Act to deal with the situation created by the shrimp culture industry and to regulate it as per precautionary principle and polluter pays. The operational part of this judgment is very pathetic. Accordingly, many shrimp culture units were closed, and to avoid this, an act was formulated, and thus the Coastal Aquaculture Authority Act came into existence. But this act was not sufficient. We know how persons engaged in the field of aquaculture suffered. Besides, the definition was so narrow that the modern developments like seaweed culture and others which were not known by that time were not included in the definition. So, this necessitated the amendment. The Coastal Aquaculture Act has specifically excluded coastal aquaculture zone from the purview of Coastal Regulation Zone notification. The recent judgment has given a different interpretation and has opened the door for more litigations. Unless this is addressed quickly and suitably, it will be difficult to attract new investments. Besides that, simplification of the procedure of registration was inevitable. Many of the provisions with respect to registration are too rigid and need to be reviewed. Similarly, a number of administrative procedures laid down in the Act need revision. For example, there is a need to clearly define the powers of member secretary under the Act for administrative efficiency and accountability. In the Coastal Aquaculture Authority Act, there is a provision of imprisonment for a period up to 3 years for carrying out coastal aquaculture without registration. For minor omissions, criminalizing it and sending poor people to jail is a very serious harassment for the fish farmers. This appears to be a very harsh punishment for an offense of purely civil nature. Hence, it has been proposed to replace the same with suitable civil instruments such as penalty. A recent order has ruled that hatcheries cannot exist within 200 meters from the high tide line, citing the provision of Coastal Aquaculture Authority Act. Further, they need to be situated mostly within 200 meters from high tide line to ensure steady supply of saline water. Accordingly, relevant provision in Coastal Aquaculture Authority Act need to be suitably amended to permit continued establishment of hatcheries. Over the time, definition of coastal aquaculture has broadened beyond shrimp aquaculture, which prompted the government to bring this amendment. The Coastal Aquaculture Act addressed the issues arising out of Coastal Regulation Zone notification. Subsequently, Coastal Regulation Zone notification had been amended in 2011 and then in 2019. So, there is a legal ambiguity whether this act will override the subsequent CRZ notification or not. To remove this ambiguity, this amendment has been brought in. There are some administrative issues like how the Coastal Aquaculture Authority will move forward in certain situations. It was not fully described. So, in order to bring clarity to this, we have tried to create and amend some provisions to bring some definitiveness into the Act so that the authority runs smoothly. For example, to make its member secretary function like a chief executive officer, it has been tried to insert some provisions, and the Coastal Aquaculture Act was made. It was thought that it is only for shrimp farming, but later it is found that there are ancillary activities such as hatchery, where shrimp seeds would get produced, without which coastal aquaculture is not possible. Whether hatchery is included in the coastal aquaculture or not, there are certain ambiguities. Through the amendment, this ambiguity is expected to be removed.